Hello everyone, my name is Natalia Willette and I'm an attorney here in the state of Florida, and I wanted to give you an update on something big that happened last night. Near the end of the day, yesterday, the U.S. Supreme Court entered an opinion regarding the CDC moratorium, effectively saying that the moratorium is no longer available to the CDC and that Congress must act in order to extend any sort of a stay on evictions taking place in the United States as a result of the coronavirus pandemic. So I wanted to make some points out of this decision because it's very important. Key language that's used in the opinion is, it would be one thing if Congress had specifically authorized the action that the CDC has taken. What this means is that the court is signaling to Congress that either they need to take action or any individual agency action is going to be considered unconstitutional. So the issue that came up here, and this is something that I addressed in the video that I made last year regarding the CDC moratorium and the unconstitutionality, is that the CDC was making this decision, rendering it based on an act of Congress dating back at least 70 years, Section 361 of the Public Health Service Act, and that specific section stated that the CDC could take action to prevent the spread of communicable diseases across state lines, and the actions that could be taken were inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated, and other measures as the judgment may be necessary for the Surgeon General. The thing is, once certain items like that are enumerated, spelled out, what that means is that similar action must be taken. Similar as in relating to those items on the list. That's what made this act, this broad sweeping act of trying to prevent people from being evicted, had no rational relationship to the kind of activities that had been authorized by Congress for the CDC to undertake in the event of a pandemic. So realtor associations in Alabama and Georgia sued to stop the CDC's moratorium. They happened to get the right to stop in the DC circuit. However, that action, that opinion in favor of the realtor associations was stayed by the fact that this moratorium was going to expire at the end of July. That's where you get the Justice Kavanaugh decision at the end of June regarding the moratorium. So the Supreme Court has now made it very clear the applicants, meaning the Association of Realtors, those people representing landlord communities, not only have a substantial likelihood of success on the merits, it's difficult to imagine them losing, quote. And so this is what I had explained before. You have these very distinct property rights, the right to exclude people from property. That's one of the nascent rights of being a property owner, the bundle of sticks of rights. That if you were going to be taking this away from people, and this is a power and authority delegated to the states, Congress would have to be exceedingly clear as to why, the basis for it, and specifically authorize it, very clearly and unambiguously authorize it. And since Congress has not done so, knowing that it was coming up for expiration at the end of July, and still we're well into almost the end of August, and they still have not extended it. This is the U.S. Supreme Court stating, hey, Congress, you're on notice. A further extension was needed, and it's up to Congress, not the CDC, to decide whether the public interest merits further action here. It has to be specifically authorized. So until Congress does something about it, evictions are a go. My name is Natalia Willette. If you'd like more videos like this, please remember to subscribe to our channel, and good luck out there, investors.